What is your stand essentially? Reply is a formality, right? Yes. TAT.
Now, all the 100 marks based on the primacy given to the qualification and primacy is wrong. According to
So it's a policy decision. What is the scope of interference in policy decision?
now, according to the concerned it relates to the recruitment that it relates to the creating what a foreign part for working the future area. Now PhD within different methodology in 2 years.
Main.
So all these things have been incorporated in the 2 years system.
And they have challenged that newly introduced system.
1730 is done away 100% based on TAT, that is the and that too after the examination of TAT was undertaken.
So rules of the games were changed midway.
One of the countries.
Because the judgments are to the effect that in the interregnum period, once the process starts, it cannot be changed. Yes.
Who have started or have begun, probably the authority would have amended this.
Yes.
But it is not the case of petition, or rather I can explain it. That
So it was amended much prior to publication of advertisement.
According to me, yes.
Very well. Yes, then let him start. What is your prayer, Mr. Joshi? Let us start from prayer. So according to you, it's absolutely illogical rule. Now first let us go to that rule, 12.1.
One for primer. Primer, they have written this 70. Only one set of rules. Vidya Sahayak, the same rule written. Shikshan Sahayak, another. 70-30.
Now Shikshan Sahayak is for higher secondary.
Second and higher. Rule 866.
First, holding and declaring clause 12.1 of the rule dated so and so is illegal. What is that 12.1? Where is it? 67. Yes.
I consult from the policy. That is an eligibility. Prescribed qualification is graduation, weightage to the post graduation, and then that too will be considered. That's the national education policy.
Mr. Joshi, you may be the expert on the subject, but I will have to gather the facts. Therefore, little slowly. Yes. page 67, 1. Selection committee shall prepare a subject-wise list on the basis of marks secured by the concerned candidate in main examination of the teacher. So, after clearing the preliminary test, eligible candidates will appear in main exams, and only marks obtained in the main examination shall be considered for the preparation of select list
So 100% weightage
to
is that
main exams.
main exam. That is the basis from which the select.
What was the rule before earlier? Where is that for comparing?
30. Preparation of select is 11.
Yes.
Selection committee shall prepare a list on the basis of weightage of 70% marks of the marks secured by the concerned candidate in teacher aptitude test to be conducted at least once in a year by interceptor and director of the education board. Marks secured by the concerned candidate in TAT will be valid for 5 years. Candidate who has secured 50% marks shall be considered to be qualified, and we are concerned with this.
30%.
Will be given out of the marks secured in the prescribed education qualification for the concerned course. There were two sets. Graduation was given a particular weightage, post graduation if I have, it was given a particular weightage. So in 30% also there was a scope for getting higher marks on the basis of postgraduate qualification. Now what is sought to be replaced is 100% TAT. Whether I am a gold medalist in graduation, gold medalist in post graduation, irrelevant. If I am in a position to secure in TAT, I go in. If I am not in a position to go in because of that, I go out.
What is usually the mode of selection in CLAT, G, NEET, in all those examinations? Whether they give weighted to the graduation or standard qualifying marks? No. We have to, when you are questioning something, we have to consider overall scenario.
Not in Gujarat, JEE.
JEE is for
That is
IIM, NEET is for medical, CLAT is for law. Yes, in all those examinations, this parameter of
So this is for admission to a particular course. This is selection for the course. There are two different things. I understand the trend. This is for the purpose of getting appointment. For a
so how that is different.
the reason for getting admission in a course, I don't need to perform orally. Interview does not have any scope. Only on the basis of written performance in either of the tests, my caliber is to be tested. Here you are selecting teachers. Qualification at every level was given importance. Graduation, I was given a weightage. Post graduation, I was given higher weightage.
But examination is of two-tier system, prelims and mains. So all the prelims is in respect of your aptitude towards the subject. Mains is in respect of your knowledge towards the subject.
Has to have IBC national education policy, which is made the basis for amending PG. National education policy says, can we see, I amend the policy. 113 maybe.
Is it for appointment of teachers?
Yes, yes.
Page number?
The notification itself mentions it. Page 96 maybe. I take on the first to page 96.
ટેટ ના આયોજન બાબત 29/4/23.
રાષ્ટ્રીય શિક્ષણ નીતિ 2020 વિદ્યાર્થીઓને સભ્યતા કૌશલ્ય જેમાંથી કમ્યુનિકેશન, ક્રિટિકલ એન્ડ ક્રિએટિવ થિંકિંગ, પ્રોબ્લેમ સોલ્વિંગ વગેરે શીખવવાની ભલામણ છે. આ ઉપરાંત વિદ્યાર્થીઓને વ્યાવસાયિક કૌશલ્યો શીખવવાની પણ ભલામણ કરવામાં આવેલી છે. આ માટે વિદ્યાર્થીઓને ભણાવતા શિક્ષકો પણ આવા કૌશલ્યોથી સજ્જ હોવાની આવશ્યક છે. વિદ્યાર્થીઓના સર્વાંગી વિકાસ માટે ભવિષ્યમાં એવા શિક્ષકોની જરૂર પડશે જે પ્રિયમ્બલ and the honorable court.
Important is on page 99, clause 9. યોગ્યતા પ્રાપ્ત કરવાના ધોરણો.
પ્રાથમિક પરીક્ષા રાજ્ય પરીક્ષા બોર્ડ દ્વારા નક્કી કરવામાં આવેલ કટઓફથી વધુ દિવસ પ્રાથમિક પરીક્ષામાં મેળવનાર ઉમેદવાર મુખ્ય પરીક્ષા આપી શકશે. મુખ્ય પરીક્ષા માટે કટઓફથી વધુ માર્ક મેળવવા ઉમેદવારે અલગથી અરજી કરવાની રહેશે નહીં. અને રાજ્ય પરીક્ષા બોર્ડ દ્વારા આવા ઉમેદવારોને મુખ્ય પરીક્ષામાં બેસવા માટે કેવળ 100 છે અને 60% ગુણ મેળવેલા ઉમેદવારોને મેરિટ લિસ્ટમાં સમાવેશ કરવામાં આવશે. તો અનુકૂળ કોર્ટને 113 vacancy.
No, before that, page 100,
Yeah.
clause 12. આ ઠરાવ અમલમાં આવ્યાથી શિક્ષક અભિરુચિ કસોટી અંગેના પ્રવર્તમાન ઠરાવો આપોઆપ રદ થયેલા ગણાશે અને આ હુકમો વિભાગના સરખા ક્રમાંકની ફાઇલ પરના સરકારશ્રીની આગામી નોંધથી મળેલ સંમતિ અન્વયે બહાર. So this supersedes entire previous policy. Have you challenged this GR? Have you challenged this GR? No.
Yeah, up to this year, it was 73.
No. What you had shown on page 24 was prior GR. This is GR dated 29/4/2023. Not 74. Clause 11.
That's the rule.
આ કઈ સાલ में?
Those are the rules. Because, yeah, this is,
2011 में.
those are the rules. These rules are replaced by these, which is under challenge.
So what is required to be seen is their legislative competence.
Right? So far as the rules are concerned. But
This is not a colorable exercise of powers or classification.
so far as is competent for the legislature to do rational research and to what is the legislative competence to not to follow. So far as the challenge to the rules of the when unreasonable units is one of the grounds of insubordinate legislation to the rules. That's what the Honorable Supreme Court. So legislative competence, yes, but unreasonable units and manifest arbitrariness is one of the grounds on which the rules can be checked. Therefore, I was taking the Honorable Court to 96. This is the national policy, the education policy. Sir, these rules are not clear. 5.4.811.
What is the preamble of the policy? Is it mandatory or it is only guidelines?
Which is now, yes.
Is it required to be followed stricto sensu? Or while framing the policy, you need to only keep this in mind? What is its applicability? To what extent it can be made applicable? Is it mandatory? Then it would not be policy. It would take the shape of act or rules. Policy means this is only a guiding factor.
If this is the policy, this what to be made of. What the purpose of attending the rules? We have to look at the policy. Is the decision in accordance with the policy? Now, therefore, relating by coming to pay the details, clause 5.
એલાનું preamble ક્યાં છે આખી policy? You have only placed on record only selected portion. Chapter 5 જ મૂક્યું છે તમે ખાલી.
This is in relation to the appointment. Which I have annexed.
A policy would be applicable as a whole. આખી શિક્ષણ નીતિ છે, national education policy. એટલે therefore I ask for preamble. એમાં લખ્યું છે ને કે to what extent this will be applicable. Yes.
વધુ સારી પ્રસૂતિઓના નિર્માણ માટે શિક્ષણ યોગ્યતા પરીક્ષા વિષય વસ્તુ અને અધ્યાપન શાસ્ત્રો બંનેના સંદર્ભમાં વધુ સક્ષમ બનાવવામાં આવશે. શાળા શિક્ષણના તમામ સ્તરના પૂર્વ પ્રાથમિક, પ્રારંભિક, ઉચ્ચ પ્રાથમિક અને માધ્યમિક શિક્ષણોને આવરી લેવા માટે તેમનું વિસ્તરણ કરવામાં આવશે. વિષય શિક્ષકોની ભરતી પ્રક્રિયામાં તેઓના સંબંધિત વિષયોમાં લેવાતી ટેટ કે એનટીએ પરીક્ષાના ગુણને પણ સામેલ કરવામાં આવશે. શિક્ષણ માટેની અભિયોગ્યતા તથા ઉત્તરાંગ તપાસવા માટે રૂબરૂ મુલાકાત કે વર્ગમાં બનાવવા સંબંધિત નિદર્શન કરવા જેવી બાબતો શાળાઓ અને શાળા સંકુલોમાં શિક્ષકોની ભરતી પ્રક્રિયામાં અભિન્ન અંગ બની જશે.
ક્યારથી?
આ રૂબરૂ મુલાકાતનો ઉપયોગ સ્થાનિક ભાષામાં શિક્ષણના સંસ્થાનો અને શિક્ષકોનું આકલન કરવા માટે પણ કરવામાં આવશે. The policy says that that also would be considered. What is sought to be done is, in my respective submission, the earlier bill was that was given 70% weightage and educational qualification was given 30% weightage.
Despite that was existing even prior to 2020, and despite this policy is introduced in 2020, meaning thereby it was found that earlier policy had its own shortcomings, and therefore to meet with or to fill up the lacuna, this policy is introduced.
This policy because there would be skills which were not having such. Our bill was falling in line with this policy. There was no need to change. That's the expectation. This is what this policy says. That can
When rules are changed, Mr. Joshi,
the
judgments are subordinate legislation. Judgments are what is required to be seen, whether it creates any unreasonable classification, whether it's contrary to the legislative competence, whether it's a colorable exercise of powers, and as you rightly pointed out, whether the arbitrariness, right? At the same time, in every act, you know, there is always a section which would empower the government to frame rules under the act. So framing rules must be in accordance with the relevant section of the act. But when?
Yes. Before that, the TAT was declared, examination was already taken. When we appeared in TAT, the rules 70-30 were in force. 70% weightage was to be given to TAT. Rest, many of us had taken a postgraduate qualification only to take it to gaining weightage. That we will be given 30%, because of which we will be able to secure more marks. Now, graduation is the only consideration. Postgraduate courses have lost complete significance. Whether I am postgraduate or not becomes absolutely irrelevant, because graduation is the only consideration now. That is the basic qualification which would entitle you to appear in TAT. Therefore, this is the respectful submission that when the original rules were there, 70-30 was there, 30% weightage was given to this qualification, out of which certain weightage was given to the postgraduate qualification. This is completely done away with, and after the TAT exam.
I could get a clue from the matter which you argued yesterday. The curriculum was prescribed, which is meant for standard 11 and 12th, and level of difficulty was of graduation, post-graduation. Therefore, if a person has studied post-graduation course, then he will find it easier to crack this exam.
My marks become irrelevant.
Unfortunately, in respect of same recruitment, 2-3 matters you are arguing, and 2 matters, and the points are overlapping to such an extent that the one which may put you at an advantageous position in one matter, the same would result into a disadvantageous position in another matter.
I follow what is coming. But the respectful submission is that
એક સમય એક જ મેટરમાં અર્જન્સી એ કરીને જો એ કરીએ જ ના તો probably there were better chances to succeed at least in one matter. But the matter which you have argued yesterday and submission that you are making today,
they are in line.
not complementing each other.
They are in line. The respectful submission is that 100% tax would not have been done, and no state has done. It is only the state of Gujarat.
Gujarat is pioneer in so many aspects. So let it be a pioneer in this way also. What I put to Mr. Virk in earlier matter, the attempt should be to search the best available talent and not about the modalities and irrelevancy of irrelevant considerations. See, you may succeed, you may lose. it's a different thing, but yes, but this seems to be absolutely in consonance with the policy, and their aim is to search for the best available talent. And nothing wrong in that. So if you want to confine it only for the purpose of interim leave, I will say that any appointments made shall be subject to final outcome of this petition. Sure. But- No, but the metro, so now this will go to December. Once the appointments are subject to final outcome of this petition, it will not cause any prejudice to special civil application number 13967 of 2024. Heard learned senior advocate Mr. G.M. Joshi with learned advocate Mr. Ishan Joshi and Mr. Mehul Sharma for the petitioner. Learned additional advocate general Mr. Mitesh Amin appearing with learned AGP Mr. Kanwa Antani and Ms. Divyang Najala for state. After arguing the matter for some time, both the learned senior advocates are agreeable that the matter is have arrived at a consensus that the matter is required to be heard finally. Hence, rule learned AGP Mr. Antani waives the service of rule on behalf of state and other respondents. It can be fixed on any date and once the pleadings are over. However, as both the councils are agreeable that any appointment given during pendency of this petition pursuant to the rules in question, the same shall be subject to final outcome of this petition, and no candidate shall claim any equity on the basis of their marks obtained in the examination, and in the appointment letter, if issued, it will be specifically stated that their appointment shall be subject to final outcome of the present petition, and the same shall not create any equity in favor of selected candidate. List the yes, list. See, attempt is to see that it can be reduced to the maximum possible extent. Matter be listed for filing on 12th December 2024 at 2:30.